Now, after the liberation of Goa, the question was, do we save these laws? Do we extend the Indian laws? How do we sort the conflict of laws? How would the concept of Unitas, which is a concept which was imported from Portugal or from Roman law into that law, there is no weightage given to the father or to the mother. There is no weightage given upon the age of the child. Now that the Juvenile Justice Act has come into force, it gives persons, irrespective of religion, a right to adopt. A father of a child was actually charged for kidnapping. Do we adopt the Uniform Civil Code of Goa for the rest of the country? Pay my respects to all the academics present here today. Many of them are no more. The faculty of law, I remember it very well. I don't think we would be where we are today in our professions if it weren't for their efforts. So, thank you, all of you. Now, as Professor Menon said, I'm not really here to talk about the boon or the bane of the Uniform Civil Code. I will give you an overview of the Uniform Civil Code as it works in Goa. But apart from sort of charting out the history of the code, I would also like to share with you some of my experiences, both as a lawyer and as judge, from outside the state of Goa, and sort of do a comparison of how the laws in the other parts of India work juxtaposed to our civil code. This is not an argument for extending the civil code to the rest of the country. I do believe that India, being such a diverse country, requires some law that is sort of common, strikes common ground to not just the several religious and caste denominations, but across cultures as well. And our common civil code being one of foreign origin, which was sort of imported and foisted upon us, I do believe that it's not really something that exactly fits what we would perhaps need. So there is room for a lot of debate, but I would believe that we need to stop looking at the common civil code that we propose to have for our whole country from a religious point of view alone. It has to be a code that works across all denominations. It has to work along with the other laws, the Indian Penal Code, for instance. And I'll give you examples where I've actually sat on matters and judged where you have these conflicts that come up based upon different laws, personal laws that apply to Hindus, Mohammedans, across the board. So I'll give you examples of those. At the end, of course, I'm leaving the question open. It's something that's food for thought. I think as citizens, we all have our role to play to evolve a civil code that would be, in a real sense, uniform across the board. Now, just to give you a bit of the history behind the civil code, it's the Civil Code of 1867. So, we have a code in Goa that's actually worked for us for over 150 years, roughly. It has been tested through various courts. It has been tested in various situations. And we can use that as a starting point, really, because it has been tested. It has worked in many ways. There are many anomalies in the law that need to be sort of ironed out, but generally it has worked across all religious denominations in Goa. It has worked in creating a fairly stable sense of rule of law over a century. Now, the code, as it originally stood, was extended to Goa by charter of the 1st of July 1867 by the King of Portugal to all Portuguese colonies. Please remember, at that time, all the Portuguese possessions, that is Mozambique, Angola, Goa, Diu, Daman, some of the islands in Kiliman, or some of the other islands in the Atlantic, like the Azores, they were all treated as colonies before this. Now, with the extension of this law to all these colonies, basically what the code did is it treated every subject under the Portuguese crown at that time as citizens of Portugal. So, unlike the laws that you had in the rest of India, where whether it was Britain or any other colonial power like France, which ruled over different areas of India, their laws were never extended directly to the to India as it was then before independence. We had separate laws that the British enacted for India, and they never treated Indian as British subjects or British citizens. So this is the marked difference in the manner in which the laws in the rest of India worked under colonial powers, juxtaposed against the law that was extended to Goa. Now, the very peculiar feature of this law is that it is premised on the theory that there would be unity in succession. I mean, this is based basically on the Roman law concept of Unitas, which is a person carries with him a law, and that law would apply to his entire estate, wherever that may be, in whichever part of the world. So, it preserves the unity of a person's estate. It grants the rights to succeed to a person's estate in its totality. You cannot separate different parts of his estate depending upon where the estate is situated. So it's to put it in a different way for those who are law students, perhaps, it doesn't go on the basis of the lesh citus, but it goes more on the basis of the doctrine of Ravoa, which goes back to the person who carries that law with him, and it applies to his estate wherever he is. Now, after the liberation of Goa, the question was, do we save these laws? Do we extend the Indian laws? How do we sort the conflict of laws? Please remember, the conflict was as severe as a Portuguese penal code which does not recognize the death penalty, as juxtaposed to the Indian penal code, which can impose a death penalty on a convict. So the question was, which laws do you extend, and how do the existing laws either continue or get modified? So just to give you a few historical events now, immediately after the liberation of Goa, after India became part of the Indian Union, if you read Article 1, Sub-Article 3C of the Constitution, basically what they did is the Indian government promulgated an ordinance of 5th of March 1962, which is known as the Goa, Daman and Diu Administration Ordinance of 1962. And this was later replaced by an Act of Indian Parliament, which is known as the Goa, Daman and Diu Administration Act 1962. Now, this act comes into force on 5th of March 1962. Simultaneously, the Indian Constitution was amended, and the first schedule of the Constitution was amended to include the territories of Goa, Daman, Diu, Dadra, Nagar Haveli into the Indian Union. Now, what's important to note is that Goa was annexed to the Indian Union by an act of war. So, as many of you would know, when it's an act of war, it has many ramifications. How do you annex that as part of your territory, or do you keep it separate? How do you extend the laws? How do you administer it? How does the existing structure continue to work along with the existing structure of the state that has, by an act of war, taken over this territory? So, what was done then is, under the Administration Act, which I just referred to, Section 5 of that Act provided that the laws applicable to Goa prior to the appointed date, which was 20th December 1961, would continue to be in force until amended or repealed by a competent legislature or authority. And with this, simultaneously, they extended, under what is known as the Goa Daman and Diu laws regulations. There are two regulations, Regulation 1, Regulation 2, one of 1962 and one of 1964. They extended several Indian laws to the territory of India, but did not extend any of the personal laws to the territory of Goa. So in one sense, Goa was sort of an island in which a foreign law, personal law operated, which is the civil code, and the rest of India, as far as personal laws were concerned, only personal laws. That is the Hindu Marriage Act, of course, there were several, Adoption Act, the Mohammedan law. None of those were extended to Goa. The laws that were extended to Goa were laws like the commercial laws, basically, the Contract Act, the Companies Act, various other codes that sort of dealt with the commercial aspects of things. Now, the question then arose, and this is a case that came up before our High Court, as to whether this law continued to operate as a foreign law within the state of India, within one of the states of India, or whether it was Indian law. It is to be recognized as an Indian law. And if it was to be recognized as an Indian law, how would the concept of Unitas, which is a concept which was imported from Portugal or from Roman law into that law, how would that concept apply to the properties of a Goan who might have migrated to another part of India? How would that apply to his properties if he held any, in any other part of India? Would you apply the civil code to that law, or would you apply the civil code to his properties in Goa, but would apply the succession laws, whether Hindu, Indian Succession Act or Mohammedan Succession Law, to the properties situated outside Goa? This was the dispute basically before the High Court. Of course, the High Court held that as far as the properties in Goa were concerned, this law would apply, the Common Civil Code, and to the rest of India, it would be the personal laws that would be applicable to that person's religion outside India, outside Goa. Now, the matter went up to the Supreme Court, and the name of the case is Jose Paulo Coutinho. It's a reported judgment in 2019-20 Supreme Court cases at page 83. And there were two questions basically that the Supreme Court formulated on this question of conflict of the extent or how this law would operate outside the territory of Goa. The first question was whether the Portuguese Civil Code can be said to be a foreign law and the principles of private international law are applicable. And the second question was whether the property of a Goan domicile outside the territory of Goa would be governed by the code, that is the civil code, or by the Indian Succession Act or personal laws as applicable to the rest of the country, that is Hindu Succession Act, Muslim personal law, Shariat. Now the Supreme Court answered this question, and I would like to read these 2 or 3 paragraphs because it's very lucidly put. It in many ways sets down in which direction a truly uniform civil code for the whole country should go. So, what the Supreme Court says is we are clear of the view that these laws would not have been applicable unless recognized by the Indian government and the Portuguese Civil Code continued to apply in Goa only because of an act of the Parliament of India. Therefore, the Portuguese law, which may have foreign origin, becomes a part of Indian laws and in sum and substance is an Indian law. It is no longer a foreign law. Goa is a territory of India. All domiciles of Goa are citizens of India. The Portuguese Civil Code is applicable only on account of an ordinance and act referred above. Therefore, it is crystal clear that the code is an Indian law and no principles of private international law are applicable to this case. We answer question number 1 accordingly. And then it further says, it is interesting to note that whereas the founders of the Constitution in Article 44 in Part 4 dealing with the directive principles of state policy had hoped and expected that the state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India, till date no action has been taken in this regard. Though Hindu laws were codified in the year 1956, there has been no attempt to frame a uniform civil code applicable to all citizens of the country despite exhortations of this court in the case of Muhammad Khan, that's the famous Shah Banu case, and Sarla Mudgar. However, Goa is a shining example of an Indian state which has a uniform civil code applicable to all, regardless of religion, except while protecting certain limited rights. It would also not be out of place to mention that with effect from 22nd of December 2016, certain portions of Portuguese Civil Code have been repealed and have been replaced by the Goa's Succession, Special Notaries and Inventories Act 2012, which by and large is in line with the Portuguese Civil Code. The salient features with regard to family properties are that a married couple jointly holds the ownership of all the assets owned before marriage or as acquired after marriage by its spouse. Then it holds that though we have held that this is an Indian law, since it is a law of Portuguese origin, we may have to take guidance from the way in which the law has been applied to come to a conclusion to see what is the intention of the law. Therefore, all the properties of the person whose inheritance is in question have to be calculated and considered as one big conglomerate unit, and then the rules of succession will apply. So what they hold basically is that properties anywhere in any other part of India would be divided according to the Portuguese Civil Code, applying the very same principle of Unitas or the Roman law principle, which I first referred to. Now, I think most of you know the features of this law, where basically marriage is not a sacrament, marriage is a contract. Another very important feature of this law is that a marriage is valid only if it is registered before a marriage registration authority. Otherwise, it doesn't have any validity. So it brings a certain sense of clarity to the contract. It has to be registered. Its terms have to be registered. The terms being, if there is no antenuptial agreement or prenuptial agreement of how the assets would be held by the contracting spouses, then the general rule would apply, which would be the system of communion of assets. Everything would sort of fuse together, and each spouse would own half of the other spouse's estate or value of the estate. If there is an antenuptial agreement, of course, that agreement would operate where there would be a separation of each one's assets, and the assets would be considered to be joint only for the purpose of the succession that the children would be entitled to. Now, the other salient features of this law, apart from the reason why I said registration, the reason why I said the concept of marriage being a contract is because I will very shortly come to the conflict situations that arise in the other parts of India, which I have experienced, as a sitting judge. Um, Divorce is another area where divorce has to be by a judicial pronouncement. It has to be by a court, a decree of a court, and it can't be by the consent of the parties without the court putting an imprimatur on that consent. The aftermath of divorce, of course, is how the properties get partitioned. So there is very clear definition of who would keep what and how the estate would be partitioned after divorce. If there is a dispute, of course, again, a civil court would sort that dispute by doing a division of the property, just like you would do in a partition suit. You could also do it by registered deed, which is exactly like a partition deed between two co-owners, and register that, and that's how you could divide the properties. Now, this system really doesn't exist in the rest of India. As you know, under the Hindu law and the Hindu Marriage Act 1956, that's the first time the laws were properly codified. There's an earlier law, but that was not really codified, but first time codified in 1956. Marriage is a sacrament. It is not a contract. Registration is not compulsory. So there's always issues whether the marriage did take place or not. If it did take place and both parties agree, then the question would be, what would be the rights of each of the spouses? The laws differ from state to state depending on the different schools of religious thought. For Mohammedans, again, you don't have, though that's a contract, you don't have a registered contract. Everything is by way of, what might be written in a private document or what's orally agreed between the parties. The question then is, how do you effect divorce under these laws? Even there is no uniformity. Amongst Hindus, the Hindu Marriage Act provides that all divorce in whichever form has to be by a decree of court. Mohammedan law doesn't have such a system. It's by talaq, and of course some forms of talaq, as you know, are prohibited now. But that leaves us with the cardinal question as to where is the clarity in terms of the contract. One is a sacrament, the others are contracts. There is no registration. So the proof of the marriage itself is a big question. You have a situation where the aftermath of divorce, there's usually a litigation because someone's claiming the other person's property. The law leaves it, the Hindu law is so different from the Mohammedan law, and Christians have a different law. Of course, for Christians, under the Christian Marriage Act, marriage is a sacrament, but divorce has to be by a decree of court. The question of whether ecclesiastical courts have a jurisdiction is still a grey area, but as of now, it has to be by a court decree. Now, there are other issues also. In the Civil Code of Goa, the question of guardianship and the question of custody of children, if there's a dispute within the marriage or dispute of both custody of, between the two parents, it's left entirely to a court to decide. There is no weightage given to the father or to the mother. There is no weightage given upon the age of the child. Now, juxtaposed against this, you have the acts that apply to Hindus insofar as guardianship are concerned and insofar as custody is concerned. Under Hindu law, the father is always considered to be the guardian of the child. But the mother is entitled to the custody of a child until the age of 5. And I'll come to the ramifications of this in terms of the Indian Penal Code. and the Juvenile Justice Act. You also have the Hindu Adoption Act. Now, under the Civil Code, you don't have a provision for adoption like you have under the Juvenile Justice Act, like you have under the Hindu Adoption Act. But you have a specific provision for recognizing the customs and usages of Hindus in Goa, which is codified, where if a couple does not have a child, they can legally adopt by a written registered document, because it's connected with the religious rites, the last rites of the father, where the son has to do the set the funeral pyre. Like under Indian law, Hindus can adopt. No other religion, there's no other law that provides for adoption like the Hindu Adoption Act. Hindus can adopt a child up to the age of 15. There is no written document required. There's no registration required. It can be by an oral act of adoption. So here again, there are questions of how do you prove this? Couples may have a child, a son, and they adopt another son, and the entire succession may go to that adopted child, and you disinherit the other child. So there's a lot of litigation in this area where the question of whether the adoption took place or not is an area where you find a lot of litigation in other parts of the country. So this is definitely an area where we need to codify this law and make it common to all religions. Now that the Juvenile Justice Act has come into force, it gives persons, irrespective of religion, a right to adopt. There is a process which is set out by CARA, and you all must be aware of the process. But in Section 63 of the Juvenile Justice Act, there is a provision that says that this act will not apply to those adoptions done under the Hindu Adoption Act. So here are two examples of where the conflict arises. I've come across these cases and we've decided them. So under the Juvenile Justice Act, there are a lot of prosecutions where it happens in reality. Children are sold to a barren couple for a price, and they register an adoption deed. Now, the Juvenile Justice Act makes this exception that an adoption under the Hindu Adoption Act, this act will not apply. You cannot prosecute anyone for it. So the question is, without even a registration of an adoption being required under the Hindu Adoption Act, it actually encourages this kind of thing happening. There was another case that we came across where this was not under the Juvenile Justice Act, but a father of a child was actually charged for kidnapping. And the provisions of the Indian Penal Code on kidnapping, they refer to someone being taken away from the legal guardianship. So now we come back to the whole concept of guardianship under different laws. So does a police officer then go to find out, is he Hindu? So which is the law that applies for guardianship? For a Muslim, what's the law that applies? For a Christian, what's the law that applies? Because by Hindu law, the father is the guardian. The mother holds the custody of the child till the age of 5. So how does the concept of kidnapping actually apply to these kind of varied cases? So you can see the fallout of not having a commonality in a civil code that applies in cases of adoption, in cases of guardianship, in cases of marriage, in cases of divorce. So I could go on, and that actually raises the moot question that I started off with. Do we adopt the Uniform Civil Code of Goa for the rest of the country? Do we modify it such that it fits into every religion's demands, religious demands, or do we ignore the concept of religion and base the Uniform Civil Code upon one rule of law that would apply to everyone and that would not cause these kind of conflicts in relation to the other laws? This is the basic question.